This AI-generated podcast is for general information only and does not constitute financial or legal advice. Please consult a qualified professional. Welcome to the Luxembourg Fundcast, produced by Bertrand Mario, a regulatory lawyer qualified as avocat à la cour in Luxembourg and Paris. This show brings you reliable insights on Luxembourg regulations sourced from curated official references. This episode is current as of 22 March 2026.
It's really excellent to be analyzing this framework with you today.
Yeah, glad to have you here. So imagine millions of euros are just waiting to be deployed into a new structure. The draft contracts are perfect. The client is demanding signatures today. And, well, the deal team is breathing down your neck to get things moving.
Right, the classic operational bottleneck.
Exactly. But as the lawyer, you stop the entire operation dead in its tracks. Why? Because in Luxembourg, taking on a new in-scope fund mandate is not, just an administrative handshake or some intake form. It is a strict anti-money laundering admission decision governed by law.
Yeah, that is spot on. If you are listening to this and you're the one tasked with compliance, you know exactly how much pressure the commercial side puts on you.
Oh, absolutely. The pressure is immense.
It is. But today, we're exploring why holding that line is not just good practice, but a structural obligation. The legal framework simply does not bend to urgency.
Right. So if we extract the immediate practical takeaways from our official sources today, what are the core truths listeners need to internalize?
Well, there are really three non-negotiable truths for your operational approach. First, you must complete the identity verification of the customer and the beneficial owner before establishing the business relationship. The sequencing is absolute.
Wait, meaning there's no let us open the file now and chase down the passport copies next week sort of allowance?
Absolutely none. It has to happen beforehand. The second truth addresses the quality of your evidence. The law explicitly prohibits exclusive reliance on central registers for customer due diligence.
So you can't just check a box because a name is on a government website.
Exactly. You must actively collect evidence and independently compare it against those registers. And the third takeaway is really the consequence of failing those first two tests.
Which is what exactly?
If you cannot meet these evidentiary thresholds, you must refuse the mandate. Beyond that, you are legally required to consider whether you need to file a suspicious transaction report simply because the client couldn't be verified.
Wow. Okay, so those three rules set incredibly high stakes straight away. Let's look at the underlying mechanism driving this. Our sources point directly to Article 2, Paragraph 1.12 of the AML, or anti-money laundering law.
Right, that defines the perimeter.
Yeah, so if you are a Luxembourg lawyer assisting a client in managing funds, opening bank or securities accounts, or setting up and managing companies and trusts, you are firmly captured by this law.
And you're also in scope if you're acting for the client in a financial or real estate transaction, or providing trust and company service provider services, or, carrying out family office activity.
Basically, the law casts a very specific, deliberate net over these gatekeeping functions.
Yes, exactly.
Think of this like a physical security gate at a highly secure facility. You cannot let someone into the lobby while you run their background check. They have to clear the check before the door even opens.
That's a great analogy.
But why is the CSSF, Commission de Surveillance du Secteur Financier, Luxembourg's financial regulator, so focused on this exact moment of entry?
Well, the policy logic, which is mandated by the CSSF, Commission de Surveillance du Secteur Financier, is rooted in a documented risk-based approach. The objective is a reasoned, evidence-based understanding of exactly who stands behind the structure.
To keep illicit funds out of the system entirely.
Precisely. And for lawyers specifically, while the rules sit within the national AML framework, supervision actually falls to the Ordre des Avocats à Luxembourg, Ordre des Avocats Luxembourg.
Right. And by derogation, the Ordre des Avocats à die Kirche.
Yes, exactly.
Wait, just for listeners who might not be deep in the weeds on legal supervision, when we say by derogation, we're essentially talking about an exemption, right? A shift in the standard rule. So the Die Kirche Bar Association handles its own members instead of the main Luxembourg body.
That's a really helpful clarification, yes. It delineates supervisory authority. And understanding who supervises you is vital because, in the Luxembourg Fund ecosystem, A legal mandate often forms just one link in a much wider chain.
Right, because your client might be an obliged entity themselves, meaning they have their own AML duties.
Exactly, but that does not relieve the lawyer of their distinct gatekeeping duty.
Okay, which brings us from the theory of the gate to the actual mechanics of unlocking it. The sources detail a 6-step legal playbook for building a defensible AML file.
Right, the practical steps.
Yeah, so if a new fund structure lands on a lawyer's desk tomorrow, what is the very first thing they physically need to do?
Step 1 is formally confirming the scope. You evaluate the requested services against that Article 2 perimeter we just discussed. Are you actually carrying out an in-scope activity?
And if the answer is yes...
If yes, you move to step 2, which is identifying the client and any acting persons. You need to gather the data on exactly who is instructing you.
Makes sense. And step 3 is verifying their legal existence and authority. But let's ground this in reality for a second. How does a lawyer actually verify legal existence? Are we just talking about pulling a standard certificate of incorporation?
Well, that depends.
Because what happens if the entity is based in a jurisdiction with notoriously opaque corporate registries?
And that is exactly where the practical friction begins. Verifying legal existence requires collecting reliable independent sources that prove the entity exists and that the individuals signing the engagement letter have the legal authority to bind that entity.
So if it's a transparent jurisdiction,
then an official registry extract might suffice. But if the jurisdiction is opaque, the professional must dig deeper. They might need to obtain notarized documents, legal opinions, or authenticated corporate resolutions.
well, I see.
The law demands reliable, independent sourcing. It does not accept "we couldn't find anything online" as a valid outcome.
So you really can't just shrug and say the registry website was down.
No, definitely not.
That leads us to step 4, which is mapping the ownership and control chain to identify the ultimate beneficial owner. Now, in a complex fund, you might have a Luxembourg vehicle owned by a partnership abroad, which is managed by a separate corporate entity, backed by a mix of institutional investors and individuals.
Right, which is very common.
Mapping that sounds incredibly demanding.
It is. It requires meticulous forensic work. The professional must trace the ownership percentages and voting rights up through every layer of that corporate structure until they find the natural persons who ultimately control it.
So it's not just glancing at a nice org chart the client sends over.
Oh, absolutely not. It's an active investigation to understand the rationale behind the structure.
Okay, and once you finally find that ultimate beneficial owner, step 5 requires you to collect the beneficial ownership registration proof, like an extract from the central register, and compare it with your own file.
Yes, that's step 5.
But the law explicitly says you cannot rely exclusively on the central register. Why is that? I mean, isn't the government register supposed to be the ultimate source of truth?
The register is a tool, but it's not an absolute shield against liability. Registries rely on the data submitted to them, which can, unfortunately, sometimes be outdated or erroneous.
Right.
So the professional's duty is to conduct an independent consistency check. If your internal mapping shows one individual controls the fund, but the central register lists someone else, well, you have a discrepancy.
And you can't just adopt the register's view to close the file.
No, you must resolve that discrepancy.
Okay, let's introduce some real-world friction here with step 6, which is determining the level of scrutiny required. So, standard, simplified, or enhanced due diligence.
Right.
In these complex fund ecosystems, you usually have a transfer agent or a fund administrator who has already done all this heavy lifting. They've mapped the chain, they have the passport copies. If I'm playing devil's advocate for the deal team, if the administrator has the data, why can't the lawyer just take their word for it to save time?
It's a fair question, and the law does permit what is called third-party reliance, but the conditions are remarkably strict. You must ensure immediate receipt of the relevant information from that third party, and the underlying documents must be obtainable without delay upon request.
So you need it on hand immediately.
Exactly. But the fatal flaw in the take their word for it argument is the allocation of liability. The final legal responsibility remains strictly with the professional relying on that third party.
Let's go back to our airplane metaphor. You can hire a third-party mechanic to inspect the engine for you. But if that engine fails at 30,000 feet, the regulator is going to look at your signature on the flight log, not the mechanic's.
That is a vivid and highly accurate way to frame it. You can outsource the gathering of the documents, but you cannot outsource the legal liability for the admission decision. Administrators are vital to the ecosystem, but they do not replace the independent acceptance decision required at the law firm level.
Right, because if the administrator made a mistake and you relied on them without checking,
You're the one responsible for the failure at the gate.
that makes step 6 critical. What happens when a file triggers enhanced due diligence? Say we're dealing with a complex cross-border structure that flags as high risk. What extra steps are suddenly required?
When enhanced diligence is triggered, the baseline requirements expand significantly. Most critically, you must establish the source of funds and the source of wealth.
Wait, just to clarify for our listeners, source of funds and source of wealth are two entirely different concepts, correct?
Yes, they are.
Source of funds is where the specific money for this immediate transaction is coming from, while source of wealth looks at how the person acquired their overall fortune over their lifetime.
That is exactly the distinction. And for enhanced due diligence, you must evidence both. You must understand and document the specific economic rationale for the contemplated transactions. Furthermore, establishing a high-risk relationship requires formal senior management approval, and it triggers reinforced ongoing monitoring.
I see. And what if we're dealing with politically exposed persons?
The hurdles are equally stringent. The law separately requires adequate risk management systems to determine if the client or beneficial owner is a politically exposed person. If they are, you again need senior approval, distinct source of wealth and source of funds measures, and enhanced monitoring.
Even in a small firm?
Yes, even in a small practice where the decision maker is the principal lawyer, this requires a real documented escalation record.
So we have this meticulous, rigid legal playbook. But let's address the obvious bottleneck here. Clients want immediate advice. Capital is sitting there. The counterparty is expecting comments on the draft prospectus today.
Yes, the commercial reality.
But this AML file has to be built concurrently. You can't just draft the documents now and promise to do the background check next month. It is literally like trying to build the airplane while flying it, but the law requires the engine to be fully inspected while still on the tarmac.
Exactly. The sequence in the law is unforgiving. Identify first, verify first, then open on a defensible basis. This creates immense tension. But the operational standard simply does not allow for improvising around the gateway.
I did notice a tiny loophole in the sources, though. There is a low-risk exception that allows verification to be completed during the establishment of the relationship if it's necessary not to interrupt normal business. Is that the pressure valve the deal team can use?
I would strongly caution against viewing it as a readily available pressure valve.
Really? Why is that?
The exception is exceptionally narrow. It requires that the money laundering risks are effectively managed in the meantime, and professionals must adopt specific, written risk management procedures governing those exact conditions. It is absolutely not a license for casual post-opening cleanup.
And looking at the actual risk landscape in Luxembourg, you'd be hard-pressed to argue that most fund work qualifies as low risk anyway.
Precisely. If we examine the Ministry of Justice's National Risk Assessment alongside the CSSF's update of the Collective Investment Sector Risk Assessment, the data is unequivocal.
What does it show?
Management companies for UCITS, which are highly regulated mutual funds, and AIFMs, which are alternative investment fund managers, both present a residual money laundering risk level of medium.
So if the baseline is medium risk, you cannot easily rely on an exception designed for strictly low-risk scenarios.
Correct. Because of that medium risk profile, the CSSF explicitly notes that establishing the origin of funds is a vital component of customer due diligence. It's a structural obligation from the outset.
So if the stakes are this high and the liability rests entirely on the professional at the gate, a verbal "looks good to me" is obviously not going to hold up in an audit.
Definitely not.
If the regulator knocks on your door 3 years from now, how do you physically prove you followed this playbook? What needs to survive in the firm's physical or digital archive?
The documentation requirements are exhaustive. The law mandates the strict retention of supporting documents, all customer due diligence material, books, records, business correspondence, and crucially, the internal analyses that led to your decisions.
Wait, so if I just have a folder with a copy of a passport and a utility bill, that's not enough. I need the actual memo or checklist showing my thought process.
Yes, exactly. You need the analysis showing how you reached your conclusion about the beneficial owner's identity and the risk level of the file. You must be able to demonstrate to the supervisory authorities that your measures are appropriate in view of the risks.
And from what I read in the regulations, you don't get to just shred this file the moment the fund closes or the transaction completes. You're married to this data for 5 full years after the relationship ends, correct?
The timeline is exactly 5 years. These records must be retained for 5 years after the end of the business relationship or after the date of an occasional transaction.
And we have to reiterate the enforcement consequence here because it's the ultimate backstop. If you are going through the 6 steps and the client simply refuses to provide the source of wealth documents, or the corporate registry in a foreign jurisdiction is a total black box, what is the lawyer legally obligated to do?
If the core requirements cannot be met, the mandate simply must not be established. The transaction cannot be carried out. It is a full stop.
Wow.
And from there, the professional must consider whether a suspicious transaction report must be filed with the authorities based solely on the inability to verify the client.
Okay, let's shift our focus from the 5-year retention look back to the immediate regulatory calendar. The sources provide several fixed dates that listeners need to track. The first date is 3 April 2026.
Yes. On 3 April 2026, specialized professionals of the financial sector must submit their answers to the CSSF questionnaire. This represents a structured data-gathering exercise by the regulator to assess market-wide compliance.
Then shortly after, we have 16 April 2026. This requires liquidity management tool information to be communicated to the CSSF for relevant UCIs, UCITS, and open-ended structures.
Right. While distinct from AML, liquidity management data collection is part of the CSSF's broader push for systemic transparency. They need to understand how funds can handle sudden redemption pressures.
Makes sense. Following that, we have dates specifically for the AML CFT standardized data collection.
Yes. For entities included in the sampled group, their deadline is 22 April 2026.
And if you're not in that sampled group,
then you get a slightly later deadline, which is 22 May 2026 for non-sampled entities.
Okay, and looking further ahead to a major milestone, 10 July 2027 is when EU Regulation 2024-1/624 applies, and Directive 2024-1/640 must be transposed.
Exactly. This represents a massive harmonization of rules across the entire European Union, moving toward a single, unified regulation.
So by July 2027, the rules of the game become even more standardized.
Yes. And if we connect all these timelines, risk assessments, and rigid playbooks to the broader picture, it highlights the unique nature of this jurisdiction.
That's so.
Luxembourg fund structures frequently combine layered investment vehicles, highly delegated administrative functions, and a vast network of cross-border stakeholders. Because of that structural reality, beneficial owner verification here is rarely a simple single-document exercise. It requires a full structure-level assessment from day one.
It all comes back to that tarmac. You have an incredibly sophisticated aircraft. The client wants it in the air immediately. But the Luxembourg legal framework is that strict mechanic standing by the engine. You must inspect the parts, verify who manufactured them, and document the safety checks before the wheels ever leave the ground.
Beautifully put. The primary legal duty is to the integrity of the gate.
And as these data collection tools become increasingly automated, it leaves us with an interesting question for you to mull over. Will the independent, qualitative judgment of a lawyer eventually be replaced by a purely algorithmic risk score? Or will the human liability at the gate become even more absolute and potentially more expensive? That's something every compliance officer and deal partner will have to weigh as we move toward 2027. Follow on Apple Podcasts, Spotify, or wherever you get your podcasts. Subscribe to Bertrand Mario, and Rigor Media on YouTube. Connect with Bertrand on LinkedIn at bertrandmario.com, all links in the show notes. This was the Luxembourg Fundcast.